I'm with David Gormley, who is an attorney in Charles County, who's been specializing lately in bankruptcy. Now, okay, so does it go to court, or how is it actually then filed that this person is officially bankrupt and these assets or these liabilities are now forgiven?
Well, primarily what we're doing is having the person give us a lot of information about all their debts, all their assets, all their liabilities. Even gets down to how many shirts do they have and how many pairs of shoes do they have.
Mm-hmm.
We got to value all that. If you're going to do a Chapter 7 bankruptcy, kind of the oversimplified rule would be is you get to hold on to about $12,000.
Okay.
If it's a married couple, $24,000. Mm-hmm. That actually goes quite a way if you don't have much equity in your house, or if you know, by the time you get your car paid off, it's devalued enough that you can probably hold on to most of what you have unless you have a lot of equity in your house or a very expensive car that's paid off.
Mm-hmm.
We draw up the petition. The person has to come in and review and sign that petition.
Okay.
It gets electronically filed with the bankruptcy court up in Greenbelt.
Mm-hmm.
The meeting with a trustee who gets appointed by the court is about 30 days after we file that.
Mm-hmm.
You got to go up to Greenbelt, meet with a trustee. You present your driver's license and social security card to prove you are who you say you are. And under oath, you're going to be asking asked questions about what are your assets and liabilities. They're going to review your expenses to make sure you don't have any really high expenses on there and to make sure you qualify for the chapter that you filed. Now, in a Chapter 7 case, most of the time what you're doing is you're filing a no-asset case because you've exempted your property under one of those, under that $12,000 exemption, and the trustee will file a report that your debts should be wiped out and you should be able to hold on to what you have.
Mm-hmm.
If you're got a small business and you're filing a Chapter 7, you may have a truck that's worth $15,000. You may have to surrender that.
Okay.
And then that money from that sale would be sprinkled among the creditors.
Mm-hmm.
In a Chapter 13, after that meeting, the next step's going to be trying to get your plan confirmed.
Mm-hmm.
As part of the Chapter 13 bankruptcy would be, all right, you're going to make a payment to a trustee for, say, 36 to 60 months.
Mm-hmm.
And the trustee is going to sprinkle that money around the creditors depending on their priority.
Okay.
If you can convince the trustee as to what that payment should be and you're paying the appropriate percentages back to creditors, after that you can often avoid that confirmation hearing, get the plan confirmed without even going to court, other than that 341 meeting with the trustee.
Mm-hmm. Now, how do they determine priorities?
Well, it's actually set out in the bankruptcy code.
Mm-hmm.
Not surprising, the federal government comes first, so that if you have some back taxes or you've fallen behind on your tax returns, you've got to get those filed before you can get your bankruptcy approved.
Okay.
And in terms of who's going to get paid first, federal government, state government, and then you're looking at your secured creditors, and then after that, the unsecured creditors.
And so if you have considerable credit card debt and you're doing a Chapter 7, and let's say you've got $15,000 in debt, I assume the credit card company simply eats that, and that is part of the cost of doing business, I would presume. Part of the reason why there are these crazy high credit card interest rates of not 15, but 25. I've heard of 30%.
29%. I often wonder if there's any loan sharks in business anymore now. So yeah, they build that into their pricing, but 15,000. There's not many people. Really, what I look at in terms of just a general guideline in terms of is a person insolvent is their credit card debt or unsecured debt close to at least over 25% of what their annual income is.
Okay.
So if someone's making $60,000 a year and they've got $15,000 in credit card debt, unless there's some other issues, I might be telling them, look, here's the credit counselor or here's a couple mortgage brokers, see if there's some other way out of this problem.
Mm-hmm. Now, oftentimes, David, you see on television, on the radio, a lot of ads about debt consolidation. You have companies that really seem very aggressive. You come in, they'll consolidate all of your debts. You'll walk in with a very low payment. And I've heard some stories where this is the last thing people ought to be doing. Do you have a sense of what that's all about?
Well, that's where you have people who I'm telling them to walk away from their house because they've taken out a second mortgage or a line of credit, and they had their house appraised at a inflated value, and all of a sudden they between a first mortgage and a second mortgage, they owe twice as much as what their house is worth. So that can be a problem. Then again, if things had turned around, if the person had been out of work for a month, needed to take out a loan to make it through, and they got back to work, over the next few years they could have solved their problems by that. It's just a question of what those interest rates are and what the terms of those rates are.
I see. Now, in terms of the changes in bankruptcy laws, is that a national or is that a state? Who actually sets up the bankruptcy laws?
Well, that's one of the things that kind of makes bankruptcy a little bit of an illogical system. I always say that what's good news in real life is bad news in your bankruptcy, and what's bad news in real life is good news probably for your bankruptcy case. Part of the problem is you have the federal system of bankruptcy. So the bankruptcy laws are set up through the federal government.
Okay.
Now, what you can hold on to gets to be set by the states.
Okay.
So, for instance, you may hear about a homestead exemption where in Florida and Texas you can hold on to your house, whereas Maryland's always been a lot more restrictive on what you can hold on to.
I see. And
there really isn't a separate exemption for your house unless you're a married couple. So, I think the old story was Burt Reynolds, when he filed for bankruptcy in, I guess, the early 80s, he bought $1 million house in Florida and then filed for bankruptcy and held on to it.
Okay, interesting.
So.
Now, I'd heard several years ago that the bankruptcy laws were modified, they were revamped. Is that with those state regulations in terms of what you could hold on to, or did the feds actually modify the different chapters?
That was the Bankruptcy Reform Act at the federal level.
Okay.
And I tend to view it as being something written by the credit card companies where they passed this law, reformed it. That did make it some good improvements. It really didn't have a huge effect here in Maryland.
Okay.
Maryland always had those strict guidelines as to what you could hold on to.
Right.
For instance, that Burt Reynolds scenario, one of the things that they said was, well, you can't use those state exemptions unless you've lived in that state for almost 2 years.
Okay.
So they kind of solved a little bit of that problem. And then they've just made a lot of guidelines where they're really, if you're going to qualify for that Chapter 7, you've got to pass through a lot of tests to prove that there's no way for you to pay back any of your money.
So in the past, it was a lot easier to declare bankruptcy then?
There was a lot more flexibility as to what chapter you could qualify for.
I see.